shout out. 3 F words. Leave a link down in the description to her channel. I do believe she is an attorney, or was an attorney. I believe she is an attorney. Pro Second Amendment. Has real good content on gun laws trying to be passed, her thoughts on them. Definitely worth checking out. So go check out her channel when you're done watching this video. As I said in my last video, please bear with me, it's going to be a lengthy one. Let's get this thing started. Here in Illinois, we have a Senate bill and 1, 2, 3, 4 House bills. Most of them pretty lengthy. I believe 11 pages, 2 pages. I believe this one was 11 pages, 9 pages. I believe this one was 10 or 11 pages. They're trying to pass laws here in Illinois that will make California look gun friendly. About the only way I think I can actually do this and do it properly is just go over them word for word. I kind of glanced over and there may be some sections I kind of skip over, but for the most part we're going to go over that. I'm going to start with the Senate bill. 101st General Assembly, State of Illinois, 2019 and 2020, SB 0107. It was introduced January 23rd, 2019 by Senator Julie A. Morrison. She is a Democrat. She is from the 29th District, which suburb of Chicago. Her residence is Deerfield, Illinois. Anybody here in Illinois, anybody that's been paying attention to laws here in Illinois, Deerfield ought to ring a bell. SB 0107 amends the Criminal Code of 2012, makes it unlawful for any person to knowingly possess an assault weapon 300 days after the effective date of the Mandatory Act, except possession of weapons registered with the Department of State Police in the time provided. Registering with the State Police, we'll get into that a little bit more. I'll follow up something later on in here. Provides exemptions and penalties effective immediately. An act concerning criminal law, be it enacted by the people of the state of Illinois represented in the General Assembly. Well, if they're voting on this, they ain't representing me. Section 5. The Criminal Code of 2012 is amended by adding sections 24-1.9 as follows. 24-1.9 Possession, delivery, sale, and purchase of assault weapons. Definitions. In this section, antique firearm has the meaning ascribed to it in 18 U.S.C. 921. Subsection A, 16, I guess. Assault weapon means a semi-automatic rifle that has the capacity to accept a large capacity magazine, detachable or otherwise, and one or more of the following. Okay, right there they said large capacity magazine. They don't have a number there. So what are they going to call a high capacity magazine? One or more of the following. Only a pistol grip without a stock attached. Any feature capable of functioning as a protruding grip that can be held by the non-trigger hand. A folding, telescoping, or thumbhole stock. A shroud attached to the barrel, or that partially or completely encircles the barrel, allowing the bearer to hold the firearm with the non-trigger hand without being burnt, but excluding a slide that encloses the barrel. Or a muzzle brake or muzzle compensator. A semi-automatic pistol or any semi-automatic rifle, that has a fixed magazine that has the capacity to accept more than 10 rounds of ammunition. A semi-automatic pistol that has the capacity to accept a detachable magazine and has one or more of the following. Okay, so my Glock 27 has a detachable magazine, 9-round mag, semi-automatic. Fire, it cycles, reset, fire, cycles, reset, fire. It's going to be illegal. Got a detachable magazine. Any feature capable of functioning as a protruding grip that can be held by the non-trigger hand. A folding, telescoping, or thumbhole stock, which sounds like Uncle Dan's got that stock for his Glock. I need to see if I can get one here in Illinois before they outlaw them. A shroud attached to the barrel, or that is partially or completely encircles the barrel, allowing the barrel to hold them. To hold the firearm with the non-trigger hand without being burnt, but excluding a slide that encloses the barrel. A muzzle brake or muzzle compensator, or the capacity to accept it. No, that's still covering handgun. Any feature capable of functioning as a protruding, let's see, semi-automatic detachable magazine. Any feature, okay. Now this is still covering handguns. Go over this again. Folding, telescoping, or thumbhole stock. A shroud attached to the barrel, or that partially or completely encircles the barrel, allowing the barrel to hold the firearm. Bearer to hold the firearm with the non-trigger hand without being burnt, but excluding a slide that encloses the barrel. A muzzle brake or muzzle compensator, or the capacity to accept a detachable magazine at some location outside of the pistol grip. A semi-automatic shotgun that has one or more of the following. Only a pistol grip without a stock attached. Any feature capable of functioning as a protruding grip that can be held by the non-trigger hand. A folding, telescoping, or thumbhole stock. A fixed magazine capacity in excess of 5 rounds. Or an ability to accept a detachable magazine. Any shotgun with a revolving cylinder, or a conversion kit, part of a combination of those parts, from which an assault weapon can be assembled if those parts are in the possession or under the control of the same person. So they're saying if the parts are not in the control of one person, they're legal. But if you're going to use these parts, they're going to be on the firearm, they're going to be in the possession of one person. So, I don't know if they're just trying to make it sound good or what. Assault weapons include, but is not limited to, the assault weapon models identified as follows. The following rifles, or copies or duplicates of these rifles. Pay attention here, I'm going to go through the list. AK, AKM, AKS, AK-47, AK-74, ARM, MAK-90, MISR, NHM-90, NHM-91, SA-85, SA-93, VEPR, AR-10, AR-15, Bushmaster XM-15, Armalite M15, or Olympic Arms PCR, AR-70, Calico Liberty, Dragunov SVD Sniper Rifle, or Dragunov SVU, Fabrique National FN/FAL or FN/LAR, or FNC. High point carbines. It doesn't say specific, it's all carbines, high point carbines. HK91, HK93, HK94, HK PSG-1, Caltech Sub-Rifle, Sega, SAR-8, SAR-4800, SKS with detachable magazine, SLG 95, SLR 95 or 96, Steyr AUG, Storm, Ruger Mini 14, Tavor, never heard of one of those, but it's on here, Tavor, Thompson 1927, Thompson M1, Thompson 1927 Commando, Uzi, a Galil, Uzi Sporter, Galil Sporter, Galil Sniper Rifle, also known as the Galatz, G-A-L-A-T-Z. The following pistols are copies or duplicates of these pistols: Calico M110, MAC-10, MAC-11, MP83, Olympic Arms OA, Tech-9, Tech DC-9, Tech-22 Scorpion, or AB-10, Uzi. The following shotguns are copies or duplicates of these shotguns: Armscore 30 BG, Sposs 12 or Law 12, Striker 12 or Street Sweeper. Assault weapon does not include any firearm that has been made permanently inoperable or satisfies the definition of antique firearm or weapons designed for Olympic target shooting events. Assault weapon attachment means any device capable of being attached to a firearm that is specifically designed for making or converting a firearm into any of the firearms listed in paragraph 2 of this subsection A. Detachable magazine means any ammunition feeding device, the function of which is to deliver one or more ammunition cartridges into the firing chamber, which can be removed from the firearm without the use of any tool, including a bullet or ammunition cartridge. Similar to California, their magazines, you can't just push a button and drop the magazine. You got to basically push a button in to push the magazine release to release the magazine. Locking mechanism means secured by a device or mechanism other than the firearm safety, designed to render a firearm temporarily inoperable, or a box or container capable of containing the firearm and that can be securely locked. Such as a safe, a gun box that can be locked. They got the locks that go down, just a cord goes through the muzzle and locks, trigger lock. Muzzle brake means a device attached to the muzzle of a weapon that utilizes escaping gas to reduce recoil. Muzzle compensator means a device attached to the muzzle of a weapon that utilizes escaping gas to control muzzle movement. The Department of State, here I'm going to go back, when I said about the registering with state police, the Department of State Police shall take all steps necessary to carry out the requirements of this section within 180 days after the effective date of this amendatory act of the 101st General Assembly. What did I do with it? There it is. Except as provided in subsection D, E, F, and H of this section, on or after the effective date of this amendatory act of the 101st General Assembly, it is unlawful for any person within the state to knowingly deliver, sell, or purchase, or cause to be delivered, sold, or purchased, or cause to be possessed by another an assault weapon or assault weapon attachment, except as otherwise provided in subsection E, F, and H of this section. 300 days after the effective date of this amendatory act of the 101st General Assembly, it is unlawful for any person within the state to knowingly possess an assault weapon. This section does not apply to a person who possessed an assault weapon before the effective date of this amendatory act of the 101st General Assembly, provided the person has provided in a registration affidavit under oath or affirmation and in the form and manner prescribed by the Department of State Police on or after 180 days after this effective date of this amendatory act of the 101st General Assembly, but within 300 days after the effective date of this amendatory act of the 101st General Assembly. His or her name, date of birth, firearm owner's identification card number, the make, model, caliber, serial number of the weapon, and proof of a locking mechanism that properly fits the weapon. The affidavit shall include a statement that the weapon is owned by the person submitting the affidavit and that he or she owns a locking mechanism for the weapon. The affidavit form shall include the following statement. Printed in bold type. Warning, entering false information on this form is punishable as perjury under Section 32-2 of the Criminal Code of 2012. Beginning 300 days after the effective date of this amendatory act of the 101st General Assembly, the person may transfer the assault weapon only to an heir. An individual residing in another state, maintaining it in another state, or a dealer licensed as a federal firearms dealer under Section 923 of the Federal Gun Control Act of 1968. Within 10 days after transfer of the weapon except to an heir, the person shall notify the Department of State Police of the name and address of the transferee and comply with the requirements of subsection B of Section 3 of the Firearm Owner's Identification Card Act. So, right there, if we transfer it to somebody other than an heir, even if it's somebody out of state, we got to provide information. Now, them people are basically registering a firearm. We're registering a form because we got to notify that who we sold or gave it to. The person to whom the weapon is transferred shall, within 60 days of the transfer, complete an affidavit and pay the required registration fee under this section. A person to whom the weapon is transferred may transfer it only as provided in this subsection. This section does not apply to a peace officer who is retired in good standing from a law enforcement agency of this state and who possesses an assault weapon if the weapon was lawfully possessed and acquired by the peace officer prior to retirement, and the retired peace officer within 30 days of the retirement registers the weapon with the Department of State Police and pays the required registration fee under this section. The retired peace officer shall comply with the transfer and notification requirements in subsection E. Subsection G. For the purpose of registration required under subsection E and F of this section, the Department of State Police shall assess a registration fee of $25 per person to the owner of an assault weapon. The fee shall be deposited into the State Police Firearms Services Fund. This section does not apply or affect any of the following. Peace officers, acquisition and possession by local law enforcement. Goes on, this we'll kind of skim through. Basically, if you work in a job whose capacity requires you to be armed while you're in lawful duty, while you're performing lawful duties, this will not apply to you. Peace officers, wardens, superintendents, keepers of prisons, penitentiaries, jails, other institutions, members of armed forces, security agencies, nuclear facilities, stuff like that. We'll go down here to section 9. Any non-resident who transports within 24 hours a weapon for any lawful purpose from any place or where he or she may lawfully possess and carry that weapon to any other place where he or she may lawfully possess and carry that weapon if, during the transportation, the weapon is unloaded and neither the weapon or any ammunition being transported is readily accessible or directly accessible from the passenger compartment of the transporting vehicle, provided that, in the case of a vehicle without the compartment separate from the driver's compartment, the weapon or ammunition shall be contained in a locked container other than the glove compartment or console. So somebody from Ohio going to Missouri has an AR-15, as long as it's unloaded, locked and everything, they can transfer it to the state. This bill is really the manufacture, transportation, possession, sale, or rental of a blank fire and assault weapons and the weapons' respective attachments to persons authorized or permitted, or both authorized or permitted, to acquire and possess these weapons or attachments for the purpose of rental, for solely as props for motion pictures, that's not illegal, television, video production, entertainment. Person who knowingly delivers, sells, purchases, or possesses, or causes to be delivered, sold, purchased, or possessed in violation of this section an assault weapon attachment commits a Class 4 felony for the first violation, a Class 3 felony for the second, or subsequent for all other violations. Any other violation in this section is a Class A misdemeanor. Effective date, this act takes effect upon becoming law, so there's no grace period, it's immediate. 300 days. Not going to do much commenting on my thoughts on that, but that's where Illinois stands with the SB 0107. Okay. On to House Bill 0174. Amends the Criminal Code of 2012. Back up here. Introduced by Representative Rita Mayfield. She is a Democrat from the 60th District, which is northern part of Chicago, resides in Waukegan, Illinois. Amends the Criminal Code of 2012, provides that the provision of the code that makes it an offense for a person who possesses or acquires a firearm and thereafter loses the firearm, or if the firearm is stolen from the person, to fail to report the loss of the theft to the local law enforcement agency within 72 hours of obtaining knowledge of the loss or theft is a Class 4 felony for a third offense rather than a Class A misdemeanor, and a Class 3 felony for a fourth or subsequent for the next offense, effective immediately. Get on here, Correctional Budget and Impact Note Act may apply, so depending on what the budget's going to be, we can change this around. An act concerning criminal law, be it enacted by the people of the state of Illinois. The following code of 2012 is amended by changing section 24-4.1 as follows. Section 24-4.1, report of lost or stolen firearms. If a person who possesses a valid firearms owner's identification card and who possesses or acquires a firearm thereafter loses the firearm, or if the firearm is stolen from the person must report the loss or theft to the local law enforcement agency within 72 hours after obtaining knowledge of the loss or theft. The law enforcement agency having jurisdiction shall take a written report and shall, as soon as practical, enter the firearm serial number as stolen into the Law Enforcement Agency's data system, LEADS, LEADS. A person shall not be in violation of this section if the failure to report is due to an act of God, act of war, or inability of a law enforcement agency to receive the report. A person is hospitalized, in a coma, or is otherwise seriously, physically, or mentally impaired as to prevent the person from reporting, or the person's designee makes a report if the person is unable to make the report. Sentence. A person who violates this section is guilty of a petty offense for the first violation. A second violation of this section is a Class A misdemeanor. A third violation of this section is a Class 4 felony. A fourth or next violation is a Class 3 felony. Effective date, this act takes effect upon becoming law. They're basically just upping the penalties on with HB 0174 for not reporting a lost or stolen firearm. here to HB0888. This is introduced by Representative Daniel Didek, D-I-D-E-C-H. He is a Democrat from the 59th District, basically covers Cook County, resides in Buffalo Grove, Illinois. When I looked him up, I couldn't find a whole lot on him other than when he was running for office. So he may not actually reside in Buffalo Grove, Illinois, but that's where it listed address at. That could be his business address. Synopsis is introduced. Amends the Firearm Owners Identification Card Act, provides that the Department of State Police shall conduct a search of the purchaser's social media accounts available to the public to determine if there is any information that would disqualify the person from obtaining or require revocation of a currently valid firearm owner's identification card. Provides that each applicant for a firearm owner's identification card shall furnish the Department of the State Police a list of every social media account. So, for one, to me that violates freedom of speech. That's only one violation right there that I can come up off the top of my head. Bill 4. An act concerning safety, be it enacted by the people of the state of Illinois, represented by the General Assembly. The Firearm Owners Identification Card Act is amended by changing section 3.1 and 4 as follows. The Department of State Police shall provide a dial-up telephone system to utilize other existing technology which shall be used by any federally licensed firearm dealer, gun show promoter, gun show vendor who is to transfer a firearm, stun gun, or taser under the provision of this act. The Department of State Police may utilize existing technology which allows the caller to be charged a fee not to exceed $2. Fees collected by the Department of the State Police shall be deposited in the State Police Service Fund and used to provide this service. Upon receiving a request from a federally licensed firearm dealer, gun show promoter, or gun show vendor, the Department of State Police shall immediately approve, or within the time period established by Section 24-3 of the Criminal Code of 2012 regarding the delivery of the firearm, stun guns, and tasers, notify the inquiring dealer, gun show promoter, or gun show vendor of any objection that would disqualify the transferee from acquiring or possessing a firearm, stun gun, or taser. In conducting the inquiry, the Department of State Police shall initiate and complete an automated search of its criminal history background record information files and those of the Federal Bureau of Investigation, including the National Instant Criminal Background Check System, and of the files of the Department of Human Services relating to mental health and developmental disabilities to obtain any felony conviction or patient hospitalization information which would disqualify a person from obtaining or require revocation of a currently valid firearm owner's identification card. The Department of State Police shall conduct a search of the purchaser's social media account available to the public to determine if there is any information that would disqualify the person from obtaining or require revocation of a currently valid firearm owner's identification card. If receipt of a firearm would not violate Section 24-3 of the Criminal Code of 2012 federal law or this act, the Department of State Police shall assign a unique identification number to the transfer, provide the licensee, gun show promoter, or gun show vendor with the number. Approvals issued by the Department of State Police for the purchase of the firearm are valid for 30 days from the date of issue. The Department of State Police must act as the Illinois point of contact for the National Instant Criminal Background Check System. The Department of State Police and the Department of Human Services shall, in accordance with state and federal law regarding confidentiality, enter into a memorandum of understanding with the Federal Bureau of Investigation for the purpose of implementing the National Instant Criminal Background Check system in the state. The Department of State Police shall report the name, date of birth, physical description of any person prohibited from possessing a firearm pursuant to the Firearm Owners Identification Card Act or 18 U.S.C. 922 and to the National Instant Criminal Background Check System Index Denied Persons File. The Department of State Police shall provide notice of the disqualification of a person under subsection B of this section or the revocation of a person's firearm owner's identification card under section 8 or section 8.2 of this act and the reason for the disqualification or revocation. To all law enforcement agencies within jurisdiction to assist with the seizure of the person's firearm owner's identification card. They come for your FOID card, they're going to come for your guns. The Department of State Police shall adopt rules not inconsistent with this section to implement the system. So basically, they're leaving it, let me read that again. The Department of State Police shall adopt rules not inconsistent with this section to implement the system. So basically, the state police have, the way I'm reading it, carte blanche on how they're going to enforce this. Application for firearm owner's identification card. Each applicant for the firearm owner's identification card must make application on blank forms prepared and furnished at convenient locations throughout the state by the Department of State Police or by electronic means if and when made available by the Department of State Police, and submit evidence to the Department of State Police that he or she is 21 years of age or over, or if he or she is under 21 years of age, that he or she has the written consent of his or her parent or legal guardian to possess and acquire firearms and firearm ammunition, and that he or she has never been convicted of a misdemeanor other than a traffic offense or a judged delinquent, provided, however, that such parent or legal guardian is not an individual prohibited from having a firearm owner's identification card, and files an affidavit with the department subscribed by the department stating that he or she is not an individual prohibited from having a card. He or she has not been convicted of a felony under the laws of this or any other jurisdiction. He or she is not addicted to narcotics. He or she has not been a patient in a mental health facility within the past 5 years. If he or she has been a patient in a mental health facility more than 5 years ago, submit the certification required under Section U of Section 8 of this Act. He or she is not a person with an intellectual disability. He or she is not an alien who is unlawfully present in the United States under the laws of the United States. He or she is not the subject of an existing order of protection prohibiting him or her from possessing a firearm. He or she has not been convicted in the past 5 years of battery, assault, aggravated assault, violation of an order of protection, or substantially similar offense in another jurisdiction in which a firearm was used or possessed. He or she has not been convicted of a domestic battery, aggravated domestic battery, or a substantially similar offense in another jurisdiction committed before, on, or after January 1st, 2012, the effective date of the Public Act 97-158. The applicant knowingly and intellectually waives the right to have an offense described in this clause tried by jury, and by guilty plea or otherwise results in a conviction for an offense in which domestic relationship is not a required element of the offense, but in which a determination of the applicability of 18 U.S.C. 922 is made under Section 112A-11.1 of the Code of Criminal Procedures of 1963. An entry by the court of judgment of conviction for that offense shall be grounds for denying the issuance of a firearm owner's identification card under this section. He or she is not an alien who has been admitted to the United States under a non-immigrant visa, as that term is defined as Section 101 A26 of the Immigration and Nationality Act, 8 U.S.C. 1101, or that he or she is an alien who has been lawfully admitted to the United States under a non-immigrant visa, if that alien is admitted to the United States for lawful hunting and sporting purpose, an official representative of a foreign government who is accredited to the United States government or the government's missions to an international organization having its headquarters in the United States, or an in or out to or from another country to which that alien is accredited. an official of a foreign government or distinguished foreign visitor who has been designated by the Department of the State, a foreign law enforcement officer of the friendly foreign government entering the United States on official business, or one who has received a waiver from the Attorney General of the United States pursuant to 18 U.S.C. 922. He or she is not a minor subject to a petition filed under Section 5-520 of the Juvenile Court Act of 1987, alleging that the minor is a delinquent minor for the commission of the offense that he has committed by the adult would be a felony. He or she is not an adult who has been educated or educated a delinquent minor under the Juvenile Court Act of 1987. The commission of the offense that, if committed by an adult, would be a felony. He or she is a resident of the state of Illinois. He or she has not been educated as a person with mental disability. He or she has been involuntarily admitted to the mental health facility, and he or she is not a person with a developmental disability, and upon request of the Department of State Police, sign a release on a form described by the Department of State Police waiving any right of confidentiality and requesting the closure of the Department of State Police of limited mental health institution admission information from another state, the District of Columbia, or any other territory of the United States, or a foreign nation concerning the applicant for the sole purpose of determining whether applicant is or was a patient in a mental health institution and disqualified because of that status from receiving a firearm owner's identification card. No mental health care or treatment records may be requested. The information received shall be destroyed within 1 year of receipt. Each applicant for a firearm owner's identification card who is over the age of 18 shall furnish to the Department of State Police either his or her Illinois driver's license number or Illinois identification card number, except as provided in subsection A-10. A-10. Each applicant for a firearm owner's identification card who is employed by a law enforcement officer, an armed security officer in Illinois, or by the United States military permanently assigned in Illinois and who is not an Illinois resident shall furnish to the Department of State Police his or her driver's license number or state identification card number from his or her state of residence. The Department of State Police may adopt rules to enforce the provisions of this subsection. If an applicant applying for a firearm owner's identification card moves from the residence address named in the applicant, he or she shall immediately notify in a form and manner prescribed by the Department of State Police of that change of address. Each applicant for a firearm owner's identification card shall furnish the Department of State Police his or her photograph. An applicant who is 21 years of age or older seeking a religious exemption to the photograph requirement must furnish with the application an approved copy of the United States Department of the Treasury International Revenue Service from Form 4029 in lieu of a photograph. An applicant, regardless of age, seeking a religious exemption to the photograph requirement shall submit fingerprints on a form and manner prescribed by the department with his or her application. Me, I don't agree with that. You want a FOID card, you're going to have your picture on it. Each applicant for a firearm owner's identification card shall furnish to the Department of State Police a list of every social media account. An application form shall include the following statement printed in bold type. Warning, entering false information on an application for a firearm identification card is punishable as a Class 2 felony in accordance with subsection D/5 of Section 14 of the Firearm Owner's Identification Card Act. Upon such written consent pursuant to Section 4, Paragraph A-1, the parent or legal guardian given the consent shall be liable for any damages resulting from the applicant's use of firearms or firearm ammunition. So, got a child under 18. I go through the process. Did it for my boy when he was not 21 yet. Actually got to go get the form printed off, get it signed. Got to sign it in front of a notary public, have it notarized, send it in. He's 18 years old. He's on his own. He lives on his own. He's married. At 19, 20 years old, he's married. He lives on his own. But yet, if he commits a crime with a gun, it's my fault. HB 0899. I'm just going to touch on the what it's about here. There's a lot of rewording that was in the other bills as far as what it takes to get a FOID card, what happens if you try to get a firearm without a FOID card. It basically stiffens the penalties for not reporting a lost or stolen firearm. This was introduced by Representative Kelly M. Cassidy, a Democrat out of the 14th District, which is Chicago North Side. Ain't that just amazing? Every one of these are from a representative or senator from the Chicago area. Her place of residence is Chicago, Illinois. HB 0899 amends the Firearm Owners Identification Card Act, provides that the Department of State Police shall revoke for 1 year the Firearm Owner's Identification Card of a cardholder who reports to the local law enforcement agency his or her firearms lost or stolen in 3 separate incidents within a 2-year period. Provides that any law enforcement agency that has knowledge that a cardholder has reported his or her firearms lost or stolen in 3 separate incidents within a 2-year period shall forthwith forward that information to the Department of State Police. Provides that an incident means an occasion in which the cardholder's firearm or firearms have been lost or stolen, regardless of the number of firearms stolen in the incident, and the report of the loss or theft of the firearm or firearms on one occasion shall be considered one incident. Provides that if a law enforcement agency recovers a firearm that had been lost or stolen and had not previously reported as lost or stolen, the recovery of the firearm shall be considered an incident. For the purpose of this provision, amends the Criminal Code of 2012, provides that the sentence for attempt to acquire a firearm by the use of a revoked firearm owner's identification card is a Class 4 felony. So basically, your house gets broken into 3 times within 2 years, you have a firearm stolen, you lose your FOID card for at least a year. It says a year, but we know how politicians work. And then it stiffens the felony if you do have your firearms owner's identification card revoked and you try to get a firearm. It is a Class 4 felony. Goes through here basically, as one of the others did, the stipulations on getting a FOID card, firearm owner's identification card. If you're under 21, if you're over 21, it does have another in here. It stiffens for like domestic related. It goes in and talks about domestic relationships, domestic disturbances. Let's see if I can find the wording on here. Talks about legal immigrants having a firearm. If you've been in a mental facility past 5 years, same thing that all the others have in it. Basically stiffens the penalty for if you don't report it. And then if you've got 3 incidences in 2 years, it stiffens that penalty to where you lose your FOID card. And if you try to get a firearm during that time, during that year, then it's even worse. They got in here about attempt to commit the offense of first-degree murder. The
sentence for attempt to commit first-degree murder is a sentence for a Class X felony, except when at least one of the aggravating factors specified in paragraphs 1, 2, and 12 of subsection B of section 9(1) is present, is a Class X felony for which the sentence shall be a term of imprisonment of not less than 20 years and not more than 80 years. An attempt to commit first-degree murder while armed with a firearm. So, even if you don't commit the murder, even if you attempt it, it's still a Class X felony for which 15 years shall be added to the term of imprisonment imposed by the court. So the court says, okay, we're going to imprison you for 20 years. Well, automatically you get 15 years added to that, now it's 35 years. I'm wondering if that ain't unconstitutional. I don't know on that one. An attempt to commit first-degree murder during which the person personally discharged a firearm is a Class X felony for which 20 years shall be added to the term of imprisonment imposed by the court. So if you discharge the firearm but still don't commit the murder, it's automatically 20 years added to whatever the judge says. Attempt to commit first-degree murder during which the person personally discharged a firearm that proximately caused great bodily harm, not murder but harm, permanent disability, permanent disfigurement, or death to another person is a Class X felony for which 25 years or up to a term of natural life shall be added to the term of imprisonment imposed by the court. If the defendant proves by preponderance of the evidence at sentencing that at the time of the attempted murder he or she was acting under a sudden and intense passion resulting from serious provocation by the individual whom the defendant endeavored to kill or another, and had the individual defendant endeavored to kill died, the defendant would have negligently or accidentally caused that death, then the sentence for the attempted murder is a sentence for a Class 1 felony. The sentence for attempt to commit a Class X felony is a sentence for a Class 1 felony. So, if you attempt to commit a Class X felony, you automatically have committed a Class 1 felony. Attempt a Class 1 felony, it's automatically you committed a Class 2 felony. If you attempt a Class 2 felony, then it's automatically you've done a Class 3 felony. Main thing on HB 0899 is the lost or stolen firearms. 3 incidents within 2 years, you lose your FOID card. We shouldn't even need a FOID card anyway, but they're hammering down on us. We got to do something. Contact the representatives, senators. Let our voices be heard. We can't let these pass. Thank you for watching. Hit that thumbs up. Hit that bell. Don't forget to check out Alex Kincaid. Great channel. Thank you for watching.